Very good morning to you. Welcome to The Big Issue. My name is Sam Adonu. This morning, two straightforward issues, yet convoluted ones for you. First is the ambulance procurement trial. The NDC this week, consistent with their threats last week or their promise last week to release a recording, which is a conversation between third accused Richard Jakpa and the Attorney General, did same this week and called for the resignation of the Attorney General. In that tape, two persons, supposedly Jakpa and the Attorney General, were seen having a conversation about the matter in court. A few things were said. One, that the accused person should find a way of getting a medical report to court so he can accuse himself. That was coming from the person, supposedly the Attorney General, to Richard Jakpa. Also in that tape, we see a situation where the Attorney General allegedly tried to get Jakpa his way of thinking, as in how he thinks the theory of the case is. That is said to be unethical by many people, and indeed the legal profession professional conduct and etiquette rules of 2020 LI 2423. A few more issues have come from this. There have been other issues about the Supreme Court judge in whose house the discussion was held in relation to this matter. Questions have been asked as to the appropriateness of a Supreme Court judge in the matter. What was his interest? What was he seeking to do? And a whole lot. Did the Attorney General have to contact a represented accused person on the phone or in person? What happened to the accused person's lawyer? We'll delve into all of this. Should the Attorney General resign? Are calls for his resignation the right thing to do? Should the president sack him, or should he be made to resign? Or you think it's no big deal? He's a good guy, he's doing a good job, he should remain at post. We would love to hear from you. Also, we'll be looking at the matter of the Palugu Dam. Some $12 million was released by the state or the republic or the government for what we call mobilization. It does appear that the minority, upon their visit to the project site, did not see much, and they question what the $12 million is being used for. The government or the government agency in charge of this project has come out to say that that money was for mobilization and not for the final completion of the work. The work actually should cost the state some $993 million. We'll delve into all of this and find out whether indeed there was some misappropriation somewhere, why the project is being stalled, and all of that. You can join the discussion as always, which is live on 97.3 Citi FM on 0596 0549 986 996, or you can do so on 020-444-7033. My name is Salam Adonu. I'll take a short break. I'll return, introduce my guests, provide you some updates, and we'll get a discussion underway. Once again, you're welcome. My name is Salam Adonu. We're looking at two main issues: the ambulance procurement or the republic, the ambulances. There are he, the Attorney General, has at odd hours contacted him to skew evidence or give evidence in a manner that will incriminate or implicate first accused, that is Forcing. They went back and forth a bit. We understand they went to the judge's chambers, came back to apologize to them. And the NDC, after court, announced that they were in possession of recordings of the promised to release it this week. And indeed, on Tuesday, they released the said 10 minutes, 5 seconds. That contained quite a lot of things. The MPP soon after that also had a press conference, about an hour apart, that the tape was doctored, the tape was pieced together to achieve a certain malicious end. That is according to the national organizer of the party, Nana Boachi, also a lawyer. Frank Davis, who is the chairman of the Legal and Constitutional Affairs of the MPP, addressed the press, and he was of the view that the Attorney General did nothing wrong. The Attorney General will not resign. He will remain at post. Indeed, according to him, he remains one of the most effective, arguably, Attorney Generals this country has seen, saving the country a lot of money, etc., etc. Quoting from the President's State of the Nation address, that the Attorney General saved the country some 10 trillion cedis and all of that. In essence, the Attorney General is doing a good job. That is what the MPP tried to put out. Now, the discussion, of course, is grown in the domain of the public, and a lot of things have been said. Many calls have been made about certain bodies, why they are quiet, why they should be speaking, etc., etc. Certain influential persons have also spoken. Ansar Sari, who is a former director of the Ghana School of Law, has spoken. Professor Etuahini has spoken. A lot of other people have spoken, and they think that the conduct of the AG has been detrimental to his office, and that the proper thing to do is for him to bow out. Do you agree or not? The second part of the show, we look at the Pwalugu Dam, $12 million for mobilization. Minority says they went to the place and nothing is happening. The agency, JIDA, said that part of that money was used to construct a 5.7 kilometer access route. Minority said that or third road at all, and could not be said to have caused. This is what morning pretty shortly, but in the meantime, just to provide you some updates, Dr. Kiselatu Forcing, the primary defendant in the ongoing ambulance trial, has petitioned the Chief Justice to televise the case. The request was detailed in a letter from his lawyers, Aziz Bamba and Associates, to the Chief Justice on Thursday, May 30. Dr. Atuforsin explained that the request was prompted by recent allegations of misconduct against Attorney General Godfred Yeboah-Dame. Last week, the third accused, Richard Jakpa, claimed that the Attorney General had encouraged him to provide false testimony against Atuforsin in the ongoing trial. The recording allegedly disclosed Godfred Dame coaching Richard Jakpa on what statements to make in court, allegedly to incriminate Dr. Atuforsin. In light of these developments, Atuforsin argues that broadcasting the trial live would ensure transparency and uphold the principles of open justice, allowing citizens to form informed opinions and hold participants accountable.
The tape allegedly captures a conversation in which Godfred Dame is head coaching the third accused, Richard Jakpa, on what to say in court with instructions aimed at discrediting the minority leader. This development has prompted the NDC to question Mr. Dame's suitability as the leader of the Ghana Bar and his role as the Attorney General. During a press conference on Tuesday, May 28, the National Chairman, Johnson Esiedu Nketia, stressed that President Akufo-Addo should relieve Godfred Yeboah-Dame of his post.
The immediate and unconditional resignation or dismissal of Godfred Dame for bringing the high office of the Attorney General and Minister of Justice into disrepute and public opprobrium. Clearly, Mr. Dame is not fit to hold himself out as Attorney General and Minister of Justice. He is unfit to be the leader of the Ghana Bar. 2. The immediate prosecution of Godfred Dame for multiple violations of the laws of Ghana. We wish to make it clear that should President Akufo-Addo refuse or fail to prosecute him, a future NDC government will prosecute Godfrey Dame for this heinous crime of fabrication of evidence. 3. Commencement of discipline by the General Legal Counsel against Godfrey Dame and his disbarment for conduct unbecoming of a lawyer, and more importantly, the leader of the Ghana Bar.
The NEC also argued that the conduct of the Minister of Justice and Attorney General, Godfrey Dame, asking a witness to fabricate evidence to deceive a court constitutes perjury. According to the chairman of the party, Godfrey Dame has undermined the judicial justice administration process in the country.
Attorney General, you are asking somebody who is before court for what you claim to be one crime to go and commit another one, to come and deceive the court. By asking a witness to fabricate evidence to deceive a court, Godfrey Dame, the Attorney General, sought to undermine the judicial and justice administration process in this. Dame constitutes the offense of perjury, which is a crime punishable under the laws of Ghana, specifically section 213 and 214 of the Criminal and Other Offences Act 1960, Act 29.
All right, so that was the chairman of the National Democratic Congress, Johnson Asiedu Nketia, at that press conference where they released the the conversation, the recorded conversation supposedly between Attorney General Godfrey Dame and Richard Jakpa. Of course, the MPP, a few minutes later or an hour later, addressed the press also. We'll bring you that in the course of the program as the discussion grows. In the meantime, my guests this morning are the Honorable Alex Segbefia. He is a Director of International Relations of the NDC and indeed former Health Minister. Bobby Banson, private legal practitioner. Franklin Kujo, President Imani Africa. And the Venerable Alex Aban, former Member of Parliament for Goma West and then former Deputy Minister for Health. Gentlemen, you're welcome to the program.
Thank you.
All right, I started with you, Alex, for many reasons.
Which of the Alexis?
Okay, I see. You have two Alexis. Okay, yes. I see. Interesting. I didn't even recognize that. All right, Alex Segbefia. and both of them are lawyers as well. So interesting. So, Honorable Segbefia, I started with you for a few reasons. One, you were the minister at the time. What started this whole thing, started the procurement of the ambulances.
Not true.
Oh, you're not the health. Okay, no, Shari'ite. Okay, so
you don't.
Wait, so you put all of that in context for us. You put all of that in context for us, but your name did come up. I know the matter is in court and all of that. So you were health minister, which means that you knew about the transaction somewhat.
Yes.
And the fact that your party has been drawn into this because one of your key members, after forcing then Deputy Finance Minister, became ranking member of the Finance Committee, now minority leader, is in the center of this. I want you to put everything in context for us. What do you know about this case and how it is proceeding in a manner that doesn't expose you too much, because I know the matter is in court and a few things have come up.
Well, first and foremost, good morning to you, Salam, and to my colleague, namesake. And I believe our other colleague is on Zoom.
Yeah.
Okay. And equally importantly to our cherished listeners and viewers. You've hit the nail on the head when you said that I'm actually restricted. One, because I was a health minister at the time, and secondly, because I'm a lawyer, which is my colleague as well. And so certain aspects of the actual case that is ongoing, one is limited in actually discussing it. Things which are factual and are not actually part of the case, I can somewhat mention and deal with. So this case went through, I think, potentially 4 ministers at the time. So it was signed when Bagbin was still a minister. Then Shari'ite took over. Then Ajiban Mensa also took over, and then I came into the picture. So I was the last of the 4 ministers who had some dealing with this case.
At what point did the ambulances start coming?
The ambulances came before okay. The letters of credit, they came. This is why at a certain point, because the case is more on the financial aspect, I actually cannot give any evidence to that directly. I can tell what has happened, and I was involved in ensuring that certain things were done, but I cannot give any direct evidence of the financial transactions, how the letters of credit were procured, etc., or how the financial arrangement, even though I'm aware of what happened. Because these are evidential matters of the case, I'm reluctant to actually go into what happened. I did a lot, that is true, in ensuring that certain things were done. But I promise you that when the time is right and this case comes to an end, I have a version, or I have my version of it, and I'm happy to discuss it. But I can't go far on that. But I can say that we can, I think, stand to be corrected, discuss what has happened recently, because they do not the confessions were, or the accusations were made in court and have been recorded on the court record as these are accusations. And the court is now, we hope, going to tell us how they are going to deal with these aspects, because it, in some ways, it goes to the very heart of a prosecution. If indeed the accusation is that the principal prosecutor has actually been contacting a witness and asking the witness to do A, B, or C, as the case may be. Now, let me first of all make a clear position on 3 areas. The 3 areas I want to talk about are the court of public opinion, first and foremost. In the court of public opinion, the Attorney General is looking extremely, extremely bad. Partially because of what was brought out by his department, which on the face of it appears not to be accurate.
Which one?
When they said that there hadn't been any sort of major contact between the parties, and then subsequently you get a tape which shows that there has been some contact. And now we are being told of a doctor tape, but I'll go into that subsequently. So the court of public opinion, in my humble opinion, has made up its mind. And as the facts unfold, they either change or not, as the case may be. But as of now, I think that a lot of people, even when you listen to lawyers, civil society, are saying, this is not looking good for us.
So the court of public opinion, in your view, thinks that the AG misconducted himself?
Yes, that is my humble opinion. Then you come to the issues of ethical considerations.
Okay.
And then you finally come to the issues of law. What? Now, I'm careful with those 2 because this piece of evidence, except the accusation being made on record, has not yet been tendered in the court. They haven't tendered the tape, and I'm sure it may come in.
Even though there are attempts to do so, there are motions filed.
Exactly. So the court is even entitled to ask for it. They can take judicial notice of the fact. It's very pertinent to a criminal trial, and so they are entitled to look for it. But if the tape is taken at its highest, you have both ethical considerations that have to be looked into, and then you have legal, possible criminal offenses that what comes to mind is, and that is a very, very serious offense. So take it at its highest. That is what technically you have on the table. And whereas the Attorney General's office were quick to talk about the matter prior to the tape being put out, they have kind of gone silent and left it to the party to now start talking. And in my humble opinion, they should never even have spoken in the first place. But if they have spoken, then they have to continue speaking. If not, so it gives the impression, at least in the court of public opinion, that there's something to hide. Or you don't have the answers. They're in a quandary. Why? First, they were not even sure there was a tape in the first place, so they were talking. Now the tape has come out. And even when the tape came out, a statement which everybody is not taking full cognizance of is that there are more tapes, or there's more to come out.
People think it's just a threat because
They said the same thing when the first tape came out.
this should be quote unquote the most damning.
Possibly.
Because if there were more damning ones, they would have started with that.
Well, I don't know the strategy of the
Very well.
team. All I'm saying is that if there are more tapes, are these all also doctored, or what is going on? But because they don't know the extent to which this matter is going, they have now learned the value of silence. To see where this actually, in fact, they've spoken too much. And they have not answered many of the questions, because whereas the impression given was that nothing untoward has happened and could happen, they even went as far as saying they have their tape. And it hasn't yet also been released. So we are waiting for a lot of things to come to the fore. But what is clear is that if you take even their argument of a doctored tape, I've heard senior journalists, senior security advisors who have said, with their experience, there's nothing doctored about this tape. They are not speaking as forensic experts, but on the face of it, because of the nature of the conversation, because of the interjections, the way the tape went, they are of the opinion that nothing is untoward about the tape. They also have no issue with the point that was raised by the MPP that the talk was for a certain number of minutes, but the recording is for less minutes. It's, for me, it's a very lame argument.
Why so?
Right, because
When it's
if
6
I'm
minutes
talking to you
also.
for 10 minutes and I'm not happy with the way the things are going, and I start to record you at 10 minutes, and we now have another 15-minute conversation, the recording will say we had 25 minutes, but I only started recording you 15 minutes into the 10 minutes into the
discussion.
Into the discussion. So what you have to show is that the tape is not authentic, and that is a tall order. Now, in my humble opinion, the reason why, because of the kind of statements that have been made by the AG's office itself, just imposed upon what has happened, it reminds me of the situation that happened with Sipayanki and also with Anani. Now, with Sipayanki, allegations were made.
Is it the Mabi and Johnson matter?
Exactly. He had to step aside, or he was asked to resign. It was looked into, and he was cleared. He came back now as CEO of Ghana Gas. Fine. Anani, similar scenario. There were allegations made up against him. It went to Shiraj. He was asked to step aside by Kufo. When the matter was over and he was cleared, he came back. Using those as examples of certain of this kind of a scenario, I think that the call for him to step aside is justified, because there are so many considerations. It's not one thing that is being, there are many answers that need to be brought to the fore, and you have to look at the position he holds and the principle of law exists. In criminal law, you don't speak, in fact, you don't speak directly to a defendant without his lawyer present. And in some cases, if you are going to do it and he is not represented, you should do it in court in the presence of the judge. That is good ethics, so that nobody can accuse you of putting any pressure or otherwise on a particular defendant or witness to do certain things, assuming you are even going down the road of plea bargaining. So I have serious difficulties in any explanation that is going to be given with regard to a doctor tape. The first question is, why were you speaking to him at all? Because you need to be doing it in a certain forum, and that was not done. So even if it's a doctor tape, why were you speaking to him? You then come to the issue of, oh well, point wasn't represented at the time the tape was, and this is another aspect. Even when they mention, and this was the MPP that mentioned the judge's in the Supreme Court judge in the first place. It didn't come from us. Because the tape that we have put out had nothing to do with the Supreme Court judge's house. It was a phone call. And the phone call, the geography of the court. It was a day when there was something more. So this issue of charge nothing to do with that, this particular conversation. But who knows to bring, we know not. You see the new that has been filed by the lawyers of Jakpa, it appears that the accusations are even graver in terms of
a promise of acquittal and all of that.
Exactly. So there's more to come. So the call for this needs to be unraveled. But can it be unraveled with the Attorney General still at post? I think not. I think that there is too much that has occurred in terms of ethical behavior, that, and in terms of the reputation of the Ghana legal profession, both at the judiciary end and the legal profession in terms of lawyers, all have been touched by this singular act or tape that has come out. And so I'm clear in my mind that for peace and the reputation of our legal profession to be kept intact, and a lot of damage has been caused, the best thing is for the Attorney General to step aside for matters to be gotten into. You see, if the first thing is that they have to, if this tape, and I said if, is made authentic, then the Attorney General is looking at a caution statement to clarify. If you are asking somebody to go for a sick note against, which is not correct, and the person is telling you that I won't do it because I'm already looking at contempt and I don't want the lady to give me for contempt. So also this issue of illegally getting a sick note, I'm not interested in it. If this tape becomes authentic, there are serious questions to be asked. And you don't ask these questions in a conversation, because that in itself is an offense. That is why I'm being very careful with how one is talking about it, because let's not joke about it. It is a very serious allegation and a serious matter, and should be given all the seriousness it deserves. Now, the other question that is coming to my mind, and it will be interesting to see how the court takes it from here, is it has some bearing on the case itself.
How so?
Well, if the implication is that we don't have sufficient evidence, or we need further evidence, and you are the one who is supposed to give it to us to convict somebody, it implies you don't have enough as it stands. So if a ruling is made by the court after it has gone through a process that this is a genuine tape, it even depends on how the trial is going to be, because what is it not be implied, or is it not a tacit admission that toward, or you don't have sufficient evidence to proceed against A or B?
I see.
That is possible. And I'm not the court. That matter must be cleared. As to the authenticity, content of the tape, etc., must be cleared.
I see. Great.
Because if you continue, for example, and any of those defendants are, and then this tape, then you have to now come and rule a mistrial or what? So for me, they are not necessarily exclusive. They are exclusive in how you deal with it or how you look at it. But when the court is going to, they cannot even say, well, no, they are that distinct.
Very well.
And that is those are the only comments at this stage till I hear from others.
All right, great. Honorable Alex Alban, but let me go to who is not in the jurisdiction and has to do something quickly. Good morning, Bobby. Welcome to the big issue.
Good morning, Solomon. Thanks for senior panelists and your viewers.
It's a pleasure. We're happy that you join us. Your immediate thoughts, passions, as we saw in last week, and then this week, and this is released the tape and all of that. What you make of all of that, and we'll delve into the other issues.
Really largely, with the submissions by Senior Seth Befia in terms of the honest, if you at this stage, I would say that there's prima facie respect of the audio that has been played against the Attorney General. That will shift the burden on the Attorney General to prove otherwise. Once that is done, you would agree with me that, as Senior Seth Befia has said, there are not only ethical considerations that come to play, but also criminal considerations. If you look at the provisions of the criminal the criminal code, there are offenses such as fabricating evidence and pushing somebody to create evidence relating to procuring medical use and all of those. Now we know that it is the Attorney General, in the name of the Attorney General, that criminal agents can commence. And so if indeed DC or any interested party decides to pursue criminal charges, the question is, in our jurisdiction, we do not have private persons having the capacity to commence criminal charges. It has to be the Attorney General. How do you expect the Attorney General then to commence criminal prosecution against himself if, for example, the ethical considerations, there's a decision of a committee to investigate? So how do you expect the Attorney General to see involves him? I am of these steps that need to be public that we are aware of. The Attorney General and our accidents have decided they evidence to decide the impact of reference to the action of a court can be traced to either a statutory provision or the inherent jurisdiction. And where there's a provision, a matter should be dealt with. You can continue on. You look at the application, proceedings to terminate. Mind you, this criminal proceedings is at a stage where submission of no case was unsuccessful, and so the court had ruled that there's a case for the defense to answer. We've gone past that stage, and so my question is whether or not, after having ruled that there's I'm using review in quote, its own decisions, looking at the fact that this evidence had always been in the possession of the defense. So at the time that they made at least Mr. Jatta was aware of this fact at the time that he made they made the submission of no case. So of no case was made and they didn't bring this evidence. They can their possession at that time, that would seek to review the decision of the court in respect of the submission of no case. The second quagmire I think the court may find itself in is whether or not you can use, because essentially the application that has been seeking the court to determine whether one there has been unethical conduct, the court exercising the criminal jurisdiction would have to make a determination of unethical conduct by the public attorney general. I want to think, and I've seen arguments that the General Legal Counsel does not have jurisdiction. I'm not sure of that, but I want to think that if the court is of the opinion that cross-examining the Attorney General, allow that to speak on these matters would lead to finding of unethical behavior, I want to think that the court may whether has jurisdiction to entertain such application. And this is devoid of the public impact that this application would have. I want to agree that there will be an aspect where they would want to play into the public domain, the public temperature. But strictly speaking, in terms of the jurisdiction of the court to entertain this application, what may want to, and whether I shudder to think of the
any decision the judge makes?
Well, Solomon, I would want to do this in reference to the judge in particular. I mean, anybody who has practiced or dealt with Justice Ifiasewa, even I was privileged to see her in practice when I finished school. She was at the Attorney General. For lack of a better word, she is one that would be described as a very hard woman who will not be swayed by public opinion or public perception. I think she's one of the judges who would strictly deal with the law, the facts, the evidence that has been adduced before her. I do not think that she would be swayed by public opinion on this. And looking at her own pronouncements when this matter started gaining public traction, that listen, don't play with the minds of the court. I'm not going to be influenced by whatever you do in the public. It tells us that I don't think that she would have any doubt at all what her jurisdiction is, what her role is, to dispense justice, not according to public sentiments or public emotions, but according to the three yardsticks that we've all come to accept, case law, precedent, and then statutory provisions. And so if that is what would guide her, I do not think that the public discourse on this matter in any way would have influence on her, judging from I would not say my only personal experience, but the experience of a lot of people that have appeared in her court, even when she was a practitioner, how she had conducted her cases and how she has conducted herself, even as a judge, both at the Court of Appeal and in the High Court. So to answer that question, I do not think that she would have any difficulty at all speaking her mind. She may be wrong, she may be right, but I think as far as she is concerned, she has said or she has concluded the way that she appreciated the evidence that was laid before her, and she appreciated the law that is applicable to the case.
Great. So that's in the court and everything having to do with evidence, facts, etc. But the court of public opinion is also very important. And mind you, of course, we all agree that there's a way the political parties involved in this are seeking to play it out there. Justice must be done, and justice must be manifestly seen to be done, as C.J. Hayworth said. You think that this, as we are seeing it, is not affecting how the public sees justice and how public sees prosecution, etc., as we have going on in our courts and by prosecutors, etc.? Is this not having any difficulty or any bearing on how the public sees justice being dispensed?
Well, I will not discount the impact of the public perception. Sometimes I would want to think that the Attorney General may have been a victim of, for lack of a better word, his own benevolence. Let me put it that way. I'm using the word loosely. Listening to the audio, everything that has come to play, I have not seen or heard the NDC or Mr. Jape's lawyers saying that there was any financial consideration. For instance, the Attorney General demanded some payment to be able to make things work or things stick. I have not heard that. So I would not want to think that there were any financial considerations or any personal benefit that the Attorney General would have. At least I have not heard that or seen that. So for lack of a better word, depending on how you look at it, depending on you thinking, okay, maybe the people involved spoke to him and he wanted to assist, maybe he's been a victim of his own benevolence, and it's something that we would all take a lesson from. But for sure, this would have an impact on how some persons think of our judicial system, to the extent that the Attorney General is involved. Remember, there have been previous discussions with the Attorney General conduct cases, particularly the, I think the LGBTQ, the abridgment of time, and all those matters where the NDC in particular, or the parties in that case, let me put it that way, have said they were not happy with how some cases were abridged other than others, and recently they were talking about changing of panel of a tribunal. And it's all of them, they have been defenses to these matters by the Attorney General. And so if they put spins on it, if they're able to present it to achieve a certain political advantage, then of course it will have an impact on it. But I'm one person that is very slow to try and bastardize our judicial system for whatever reason, particularly when you see that there are political advantage to certain persons who will be promoting this alleged discourse. The reason being that I've always said the judiciary is the only arm of government that we don't vote for. And so as much as possible, we should try and protect its independence and make it as sanctimonious, for lack of a better word, as possible. Because justice is not administered to persons on political party lines. We may speak about these matters, but the judicial system is made up of hundreds of judges, hundreds of judicial service workers that is supposed to serve the almost 30 million population in Ghana. What is the percentage of the cases, so-called politically exposed cases, that the judges listen to or administer justice over? And so if we want to generalize the justice delivery system based on one happenings involving a politically exposed person, then I will not agree with that suggestion. But with every human institution, there's bound to be mistakes and faults, and it's never going to be perfect. And so if we learn from this mistake, we would make it better. And then at the end of the day, every person should be confident approaching the judiciary to have a resolution of a matter. The farmer whose farm has been taken away from somebody who is operating a galamsey may not be a politically exposed person, and his only recourse per our constitution would not to take the law into his own hands, but to go to court. And so if we bastardize the court to the extent that the ordinary Ghanaian will not have confidence in it, then it will come back to bite us. We as a people will lose. So when we are discussing these matters, I would hope that we limit it to the particular circumstances of the case, other than generalizing it, so that we do not erode the confidence that the general populace would have in respect of our judicial or justice delivery system.
I see. Briefly before you go again.
This is very important. No one has attacked the judge.
No. Yes.
It's very important.
Yeah, I think yes.
Attacked.
Oh, no.
I think I was making a general point.
But it's important to just clarify that.
Yeah.
Yes.
I think I was just making a general point here.
Yes, it was because of the question that Salom
was asked. Yes.
Yeah.
Okay.
So Bobby, that's fine. So many have also questioned the silence of the GBA. Is it a concerning matter to you that the Ghana Bar Association, which has been vocal in the past on many matters, has been quiet on this more than a week or a week into the matters?
Yeah, so I was also surprised when people started dragging the GBA into it. The GBA, when they choose to speak on issues, you can check their record. At least since I joined the bar, they never speak to it immediately, because they would want to actually ascertain for themselves and have evidence and facts, so that they do not go and say something that end up not being the real case. And so I would want, and the GBA is not made up of only one person. The executives. So perhaps at their next meeting, who knows, they may consider it and then issue a statement. So I think we are very quick to judge and bring the GBA into it. Let's wait, because in all matters that they have issued public statement on, it takes quite some time. You would agree with me, not immediately. And this matter has been, how, at least when the tape was played, it was only earlier
on Tuesday. On Tuesday.
Yes, today is Saturday. So let's give them some time. If within 2 weeks, 3 weeks, they do not issue a statement, then we can begin to question why they are silent. But I think that it would be rash to think that immediately it comes out, they should issue a public statement. Maybe it's been penciled for the next executive meeting, who knows? So let's give them some time.
The MPP has said the tape is doctored. It's been pieced together to achieve a certain political end. They've also said that the conversation was about 26 minutes or so. Only 16 minutes of that was played. Does it matter that out of 26 minutes or so, only 16 minutes was played?
Like I said, in these matters, we know that he who assets must. If a prima facie evidence is made, it shifts the burden of persuasion to the other side. And so if the NDC has in their possession 16 minutes and they have played it, and you say there's 26 minutes, I would want to hear it. Then I would want to see because you cannot say there's a doctored tape unless you're in possession of an original one. And so I would want to hear it before I make that conclusion. Whether or not it makes any difference to what has been said, I have heard the voice. I have no doubt that is the voice of the Attorney General. I'm not an expert from hearing the voice that it's been to determine whether or not there has been cut and paste here or it's been doctored. But if we have the benefit of listening to what the MPP would say will be the original tape, then we would be better judges in this matter.
I see.
And like Senior Befia said, the first statement that was issued by the Attorney General's office, even before the tape was played, suggested that there had not been any contact in any form at all with the said person. And so if subsequently an audio is played that suggests that there has been a contact, then it defeats the earlier statement that was issued, whether or not it was intended to deceive the public or whether it was done out of ignorance. It raises all issues. And now you say there's an original tape. And so if there is and I hear it, then I'll be able to make a fair assessment of whether the 16-minute tape was doctored to achieve a certain political end, or actually it is what it is. So until I hear the original tape, it will be difficult for me to make a judgment of the authenticity of the 16-minute tape.
You think that the will make or are making the Attorney General's office or department suffer any reputational issues, at least as we've seen it now?
That is why I agree, because the Attorney General's office is made up of hundreds of lawyers. It's the one that this alleged reputation, if for lack of a better word. And if that is it, and we are not careful in that office and allow the perception to fetter, it may affect the reputation of the officers, Attorney General's office, who have from the one who have assisted in preparing witnesses, cross-examination, and all of those things. If all are test or strictly application of the law of evidence, those efforts all along were undermined by these extra, for lack of a better way, judicial discussions that have gone on. So I think that in the may be wondering what this is all about. And so it's good that there are thorough investigations, and then the name of the Attorney General himself is cleared, and that to a large extent will affect those that have participated in preparing these dockets or other related matters.
All right, thank you very much, Bobby Banton, private legal practitioner. Thank you so much for making time for us this morning. Wish you the best of the day. This is a big issue on 97.3 Citi FM. We're looking at the matter of the ambulance procurement trial. We're analyzing the implications of the leaked tape that the NDC played released earlier this week, which supposedly or allegedly had in the Attorney General and then the third accused person, Richard Jakpa. My guest, Alex Segbefia, Director of International Relations of the NDC, former Health Minister. You just had Bobby Banton, the Honorable Alexander Aban, former MP for Goma West and former Deputy Health Minister, is my guest. He's also here. And Franklin Kujo, President of Imani Africa. I'll take a short break. When I come back, we will now have time for the Honorable Alex Aban and hear his submissions. Don't go away. Very good morning to you. Welcome to the big issue. Very warm welcome to our TV viewers as well. My name is Selom Adunu. This is the big issue. This morning, two key issues we are dealing with. The ambulance procurement trial. We're analyzing the implications of the AG's leaked tape, a matter that has dominated public discussions right from last week when the allegations were made in court that the AG tried to get a third accused person. He spoke himself in court and it was recorded that the AG tried to get him to give evidence that will advance his case against the first accused, that is Atu Forson. And Atu Forson is a huge figure in Ghana's politics. Indeed, he is the minority leader in parliament, and that's huge. Also, former deputy minister for finance and also ranking member, former, on the finance committee. So you can understand the bigness of the matter. Also, we'll look at the Palugu Dam issues. $12 million released for mobilization. Nothing much has been happening according to the minority who visited the site. They said the site is abandoned. What happened to the $12 million? The GIDA, Ghana Irrigation Development Authority, which has some role to play in the dam, etc. Of course, the dam is under the VRA, or yes, under the auspices or under the VRA, but GIDA has a role to play in that. They say that the 12 million was not for the final work, it was for mobilization. The minority hit back to say that the site is deserted and the road that GIDA says has been constructed is actually a donkey path, not a proper road. And that and all of the things they talk about could not amount to $12 million. And so we're asking if it's a case of misappropriation or what is it? Why have they abandoned the site? Is government not releasing money for the start of the project? A project that Dr. Bawumia says was the single biggest investment for the northern part of the country to cost $993 million. To help us do the discussion this morning, Alex Segbefia, Director, International Relations, former NDC, and NDC, former Health Minister under the NDC regime. Bobby Banton, we spoke to earlier, private legal practitioner. Alexander Aban, former MP Goma West, and Franklin Kujo, President Imani Africa. In the second part of the show, we'll be joined by other persons with specific expertise on issues of the dam. Honorable Aban, I mean, we've heard from your namesake, Alex Segbefia, we heard from lawyer Bobby Banton as well on what they think the implication of the leaked tape is. What's your own view about the leaked tape, the manner in which it came up, the issues that have dogged it, etc.?
Thank you very much. Good morning. Good morning to my namesake and our cherished listeners and viewers. Let me start by making some general observation. It appears to me that in Ghana, if you want a case to be destroyed,
Put it in politics.
for lack of better word, just politicize it, and you're fine. You see, the real grain of this matter is whether indeed some crime had been committed, whether there had been some financial loss occasioned. That should have been the focus of discussion. Unfortunately, because the political parties have now come in, the matter has now been swept under the carpet, and what has now taken the front burner is the conduct of the Attorney General, whether it is good or it is bad. This issue of unnecessary politicization is making us lose focus in many of the things that we have to do. If we take crime as crime, and deal with it devoid of the political considerations, probably we would move a step further as a country. That's just now the crime which has been committed, allegedly committed, is pushed somewhere. Is it true that we procured some containers which were paraded as ambulances? That's what the country needs to know. But once you are a politically exposed person, get your political party to be by you, issue statements, you get a rebuttal from the other end, and then the matter is swept under the carpet. It's sad. We should isolate real criminal issues or even civil matters from these political considerations. Indeed, I say that the NDC has succeeded in pushing this into the turf war, the turf battle of political football between MPP and NDC with their press statement. It was a bait, and the MPP quickly picked that bait.
But MPP couldn't have been quiet. They had to come out and defend their own.
I think we should have allowed the institution of the Attorney General to deal with it. Now it has become NDC MPP. Is that not the case?
Yes, but that inures to the benefit of the MPP, because one of their own is being chased. And from what we heard from the beginning, from Alex Segbefia and from Bobby, it did appear that the communication, when they left it to the AG's department, they were not doing a good job. Also because they were not privy to the full facts. So like the first statement issued by the AG's department, when you read it, it appeared like they thought there was no contact whatsoever. Now the conversations and the Supreme Court judge, all of that show that...
Most probably they could have got some individual or some CSO to pick it up. Now that it has become NDC as a political party, MPP as a political party, before you realize it's not about the alleged crime itself, right? It's about something else.
But if
And
they feel,
that is
if they
what
feel
is
that...
leading. This is just a general observation anyway, so I don't want us to debate it so much.
Great.
And that is what has now become the issue, right? The real case is being pushed somewhere. Let me also enter this, I don't know whether I should call it a caveat. I want to make this confession. The Attorney General is my very, very, very good friend. In fact, we were in Commonwealth all together. At the time I was JCR president, he was my Attorney General. So probably at this time I should be president.
Where did you go wrong?
Oh, so he was your Attorney General.
Yes, so that's on the lighter side.
See.
So when I was JCR president, he was my Attorney General. So we have been very good friends.
Were you guys mates?
Yes.
Oh, you're mates?
Yes, we met.
You're called together?
No.
Okay.
I was not reading law at that time.
Oh, okay. I understand it.
So he was my Attorney General in Commonwealth. So we date back, way back. So I have some kind of inertia.
He's been an Attorney General in waiting for a long time.
Yes, he's been an Attorney General in waiting. Probably I first made him Attorney
I see.
General.
He should be president by now.
You saw his potential.
Of course. He is a fine lawyer. We cannot run away from that.
I'm not disputing.
Very good lawyer. And beyond that, we were in Akufo-Addo chambers together.
Oh, you were in Akufo-Addo chambers too?
Yes. And so I must underscore these things before I go into the merits of the matter. Now, the question is, everybody is talking about the tape. Let us start raising questions. And then probably we will see the malafides with which it was done. And probably, as Bobby said, the Attorney General being a victim of his own benevolence. Who initiated the call?
We don't know, but we think...
Good. It is one of the things that we must start interrogating. Was it the Attorney General or it was the other way around?
This particular call.
Yes. So I think it will show
this
from the
particular
screenshots.
call.
Yes.
It was initiated by the Attorney General.
Attorney General initiated.
You are saying
this
I don't
one.
know.
No, I think it's we can find out because they have the WhatsApp screenshots. So the WhatsApp screenshot will show who initiated the call. Yeah. So that we can find out. So we can take what he's saying for granted.
So if we are talking about WhatsApp and all that, then it means it's a chain of conversation.
Yes.
So we may even have to start who initiated that conversation, because that whole gamut should be put together. Because if we are chatting, and it gets to a point I realize that no, this thing, let me call back. It may not necessarily
be you initiating the conversation or the call.
So it is not just about the call. What was the motivation for Mr. Jakpa doing the recording? What was it for? Right? That's also a question begging for answers. It is necessary that we look at it. In this whole meeting at the Supreme Court Judge's house, who initiated it and what it was for what purpose?
Did you say meeting or meetings? We don't know.
Okay, so at least we know of one.
For now, looking at all the facts that we have, we can at least talk about a meeting,
of course.
And we can also talk about a tip or a conversation, a phone conversation.
Yes, okay.
Because it would make no sense that when we are meeting, we are also having a phone conversation.
Yeah, of course.
It would make no sense. So obviously, these are two separate
time frames,
occasions.
Yes.
Right? So at least there was a meeting. But Mr. Jakpa made it clear on the tape that, we've been meeting, we've had meetings at the judge's office, home. Okay? And you have always been asking me to do this. Was that statement conditioned by his intention to create the impression that there had been series of meetings? One question which we must also interrogate. Because if you listen to Mr. Jakpa, in the context of that discussion, you are likely and probably invariably led to the conclusion that it is not even one meeting, and that there have been series of meetings in the house of this Supreme Court judge. Nobody has brought in the Supreme Court judges, but it would be strange that the person at whose behest these meetings have been held in his house had no conversation at all, had no role, nothing to say in this. That is also an area we may have to look at. Now, let's go to the case itself. I have seen the application that has been filed. I will look at its procedural propriety later. But if the content, of what has been filed is anything to go by, the merit of the case is not affected in any way. I'm going to explain why. At the time that this tape came up, and from the affidavit and the attachment that they have given in the application to either terminate or stay, they have deposed to the fact that Mr. Jakpa had already given some kind of viva voce evidence and probably had been impressed upon to file a witness statement, which he had done. So to that extent, his evidence in chief had already been given. And there was nothing more to be done. If there was anything to be done at all, it was his answers to questions that would be elicited through cross-examination. Yes, because that was the stage where we were. And indeed, on the very day that this disclosure was made by Jakpa in the courtroom, he was being cross-examined by the lawyer for the first accused person. And there is everything to be said, in justification for why the lawyer for the first accused person would be asked to cross-examine him before the Attorney General would do so. So that the first accused person's lawyer, knowing that the two of them are on one side of the case, would not use his cross-examination after the Attorney General's one to do re-examination and correct issues. So the court has the power to order I'm going to give the order in which the cross-examination will have to take place. So in this matter, the lawyer for the first accused person was actually cross-examining. It was in this that the Attorney General came. That was around 1:30 when a lot of things had already passed down the drain, right? Then I think he made some observation, he made some intervention. That was, in response to that intervention, what Mr. Jakpa said, the Attorney General has been calling him at all hours, blah, 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 blah. Then they brought this tape. But look at the time between these disclosures that were made in court and the publication, if I may put it that way, of that tape. I am very skeptical, and I take my time to come to wrong conclusions or to attribute wrong things on anybody. But I can assure you that if the tape was there the way it is, it has been put out, probably immediately they would have just brought it out. Right? I am not an expert to say that the tape has been doctored or something like that. But you realize that Mr. Jakpa keeps saying something which appear to be in response to what the Attorney General may have said. Yet what the Attorney General himself may have said is not captured.
As in what exactly? The way he wants me to answer questions?
Yes. Because if you listen to the tape very well and you want to be very analytical, you realize that it comes out of the blue. Because it's not as though the Attorney General had said, oh, when you go, say this, say that, and then that rebuttal from Mr. Jakpa comes in. He repeats that about 3 times, probably for emphasis. That's what I'm asking. What was the motive? Was it...
But we also didn't hear the Attorney General debunk that entirely. He didn't.
Indeed. Personally, I had a problem with my friend. That when the gentleman said that, immediately, he should have said, hey, what have I told you that you are saying all these things?
But he didn't.
Okay, yes. And you know, one classic case of the Republic versus Bedingfield. Okay, when somebody says something which is very contrary to you and it is incriminating, it is reasonably presumed that any reasonable person within that time would quickly give a rebuttal. So,
but we didn't see that rebuttal.
I didn't see that rebuttal too. And I want to be fair to the facts here, right? So, to that extent, I thought my friend just gave himself up too much.
And also, I mean, not to complicate matters, but also when we listen to the discussion, at some point, he felt that he could be recorded. So if what you were saying was nothing wrong, why will somebody recording you be an issue? So he felt he was being recorded and wanted to end the conversation. Something else came up and he continued talking.
I don't think we should see it that he realized at that time.
No, he felt because he
felt at that time that he had said something bad. He could have concerns that he's being recorded, not necessarily because he has said something incriminating or something bad, but probably some other person may have some collateral reasons for doing this. And I'm here saying that the collateral reason is that let us throw it into the public domain so that we appear to be victims. And that's all the more reason why they are asking for a stay or a termination. Now, if you say you're going to stay, from our jurisprudence, you know that you stay because there is something else pending. What judicial matter is pending here?
And what is the state supposed to do?
What is the state supposed to do? And if I may sound a little political...
Or stay in perpetuity? Or,
it doesn't make sense. And if I may sound a little political, it's like, okay, let us
stay till we come.
Stay
till we come.
And see if we could use all these gymnastics
to delay the thing.
What we call juju and tricks, to delay it in the event that we go to the polls and tables turn. Oh, the Attorney General who will come will just enter nolli prosequi, and that would be the end of matter, right? So it is part of the delay tactics. We cannot run away from it. That is being political, and even political here. I'm just being cautiously political, not necessarily very partisan, but it is something that probably as lawyers we all do for our clients one way or the other, especially when your client owes and he's buying some time to look for the money to pay and all that. You understand? So I believe that it is one of those areas, and my friend knows. I'm sure he did some practice. If he did, definitely he will know how to say, oh, you know what, let's file this application. It will give you some 3 weeks. In 3 weeks, go and arrange, and then let's just go and pay him so that they don't go and sell your house. I mean, we all do it, right? So that's
speak for yourself.
Oh, you do it. So coming from that point, I think that this is what they want to do, right? Now, the call for the Attorney General to resign, it is just to score political points and nothing. Because you see, if you say that there is something untoward, bring the notice application, okay, to the appropriate quarters.
Necessary application to get the AG removed or replaced?
Oh no, you see, that one becomes the president's decision.
So they've made a call.
Okay, so they have made the call. But I'm saying that in this call, it's not so much that the Attorney General has done something so grave that he should resign immediately. But
let's interrogate that. So, for example, in the tape, we heard the Attorney General suggesting to the witness or to the accused that he should go procure medical reports, which obviously is not correct.
I think I listened to it so carefully. And if you listen to the
tape, you could get a medical report. But if you want, the guy is not sick. So what should you go and how does he do that? He's not sick.
Fine, but the thing is that
you suggest he didn't even say he has difficulty attending court. He wanted to travel, come back and meet the evidence or the testimony. And he said, if you want, you can go and do that. And the guy thought that it was the Attorney General himself who was to go for the medical excuse. And he said, no, not me. And so the guy said, no, you want this woman to come after me again with a bench warrant for a bench warrant or something. So it was a suggestion made to the witness or the guy by the Attorney General.
Good.
And
that's something we would describe as indiscretion.
And that would be grave indiscretion.
Truly, but the thing is that, you see, he told him.
No, but I can't say. You see, that will amount to the gentleman misleading the court or deceiving the court, because you will not be sick, but you would have procured medical excuse for whatever reason. It will not be proper, and this would have been done upon the advice of the Attorney General, leader of the bar.
Yes. So you see, I don't want to hold brief from my friend, right? I have already told you he's my very good friend.
Yes.
But you see, I would not hide my own disappointment in that suggestion, no matter how innocuous it sounded, right? Because he said, if you want. And the guy said, hey, I have already had a brush with this woman. You want me to go and do that again, right? For her to cite me for contempt or something like that, because the earlier one, she issued a bench warrant against me, right? So for me, I think that let us interrogate the matter very carefully and isolate the facts of the case itself from this. So if the Attorney General steps aside, what next? Will the case continue?
No, so the person of the Attorney General would have left the case.
But when you go to the Attorney General's department, there are many persons who work under him and who conduct cases sometimes without even reference to him. Of course, even if it even comes to the police area, the person they go to see is their jupo, right? And all discussions go on there until probably there's an appeal. And then the Attorney General and his people will come in. So we should not make Mr. Dame to be the embodiment of the whole department. Of course, he's a leader, I understand.
And it's his person that was involved in all these discussions. The phone call, the meeting with the judge, the conduct of the case in court. You know, the day of the incident, he was there. It was his comment at the bar that occasioned the response from the gentleman. Who knows, if he hadn't said what he said, maybe we would have finished this trial without knowing this matter. Maybe it wouldn't have come up at all. Because, like you said, the gentleman had always had in his possession this tape and this information. But he never said it. I don't know when he was going to release it because it was not in his witness statement.
Yeah, so if the Attorney General, because I've asked a question which we must answer. If the Attorney General steps aside now, what happens to the case?
The case continues. So it,
Good.
Yeah,
So
the case continues. Yes.
So if he does not resign, but he doesn't take personal conduct of the case, will the case not continue?
Yes, but he's the boss.
Perception is wrong.
He's the boss, and people will come to. He doesn't have to. I'm not sure he's conducted the case every day himself. He may come to court when he needs to, but they take instructions from him. So go do ABC. I'll not appear, but this is my mind. Go and do it this way, and I'll go and execute it the same way my boss has said. So the argument is that his continuous stay in office compromises the process.
I don't think so. I have already told you that his indiscretion, I agree. But I'm saying that no matter how we look at it, it is not going to affect the case itself, especially when the gentleman has already filed his witness statement, meaning that he has led his evidence in chief already. Now, my mother would say, "No, quite the I mean, everything that you want to say it, you process it and say it, right? And so, if somebody else from the Attorney General Department comes to ask you questions, you answer it the way you want. Indeed, if you look at the evidence that, the record of proceedings that they themselves have attached to the application they have brought, there were countless occasions that the judge had cause to warn him that answer the questions that have been put to you directly and straight forward, right? Because he will be beating about the bush. I took my time to read the record of proceedings that they themselves have attached. And so there have been history of that. And if the Attorney General or anybody coming from the Attorney General's department comes to ask questions, this guy has already indicated to the Attorney General that I'm not going to follow you the way you want me to conduct my case.
And that was reflected in his witness statement.
Yes. And so his witness statement is there. It will even be in his own interest to stick to his witness statement when they ask him questions. Okay? Unless, of course, evidence is so overwhelming, which is contrary to what he has said. And probably he crumbles under it and makes some admissions which are contrary to what he has stated. But otherwise, at this point, nobody can change what is there. And nobody can influence the mind of Jakpa.
Very well.
So he must just go on, deal with this case. Let us draw the lines. Now, the propriety of that application.
I wanted to go to Franklin and come to you.
Very well.
So we do that one. All right, Franklin, welcome to the program. I know you've been listening to the lawyers speak and all of that. You've heard the tape. Last week when we were speaking, we hadn't heard the tape. We've heard the tape. We've heard what's on it. I don't know what your initial thoughts were when you heard the tape. You think the tape has a lot to down the Attorney General, or you think it just amounts to nothing?
Well, good morning, Salom. Good morning to my good friends. Can you hear me, by the way?
Very well, yes, very well.
Right, okay. Well, at some point, when all this was unfolding, I made a post and said, the AG is many things. I mean, I've been on record to say that he's very vindictive, he's very wicked, the things he did to Sal, some of the things he did to the Asinov guy. So, but at the point I was like, whoa, wait a minute. Is this really true that he actually was coaching someone to break the law and actually just find a way of implicating somebody else? Now, these things, you see them in movies, right? Even if they are biopics of people like, what's the guy's name, the American president, Richard Nixon, and all the things he did, that subterfuge, trying to, what was it?
The Watergate scandal.
You remember that story, right?
Yes. It's the Watergate scandal you're talking about.
Watergate scandal, right. But then I had all these flashes. I was like, no, I don't think Dami would do that. Dami could do Sal, he could do Asinov, could do all kinds of things, but not this one. And then here we are with a tape, which has not been denied by himself and denied by anybody else that is close to him. And I'm beginning to ask myself whether some of these highly charged political cases, or political in quotes, were not also procured under fraudulent conditions. I'm beginning to think, wow, right? Many cases, and that's what in an enlightened environment, that's the kind of question we start asking. You go back in time and ask yourself, okay, let me say, that's why this man did this. So, for instance, even if you bury me 100-foot, I'll get up and tell you that it was a grand plan involving government agencies, and Dami was a coup de grace. Basically, that is exactly what happened. But I'm surprised that he actually perfected the art and went ahead coaching somebody, a gentleman who now says that his conscience cannot allow him to be part of the Machiavellian type of arrangement to kill somebody willingly. I've said that this case is a very stupid case. Excuse my language. Stupid case, a political case, because clearly speaking, Ato never really. What was the point? And the LC has been anyway. Those are merits. I'm sure you lawyers will say it's still in court. So, well, let's leave that. But look,
exactly so.
So you could see that it was clearly intent. I'm hearing that he said the AG said to Jakpa, finance minister and the president are pressurizing me. They have to do something to this case. Well, hell no. You are the minister for justice. Even if you are told to do whatever you are being asked to do.
No, but frankly, that's just an allegation being made by the accused person. The AG says that's not true.
Well, first of all, there are so many things. I don't think Jakpa manufactured the same way. Jakpa is not a stupid man. Jakpa recorded you was Jakpa's not even leading you. I'm tempted to believe Jakpa more than the AG right now. There's nothing the AG said that I'll believe him ever again, by the way. So at this juncture, Jakpa rules. And you see, Jakpa is saying that Jakpa must have asked at a point, why all this? Why are you so determined to jail this guy? And I'm sure that's how he procured that answer. That finance minister, president says I should get the guy jail. And I believe this story, by the way. I believe it 100%. Anyway, let's leave that for now. So,
so these remain allegations. So we are here to see what proof he has. Maybe he has a tape, maybe he doesn't. Maybe he has something. If he has something, he should produce it and we'll see.
Yeah, but you see, common sense will tell you that. Jakpa, given the demeanor of Jakpa and the very excellent nature in which he acts, he kept goading the AG. You must have asked at some point that you cry. Why they worry me like that? Why won't do this guy? And I'm sure you must have procured that answer. But let's leave it there. It says allegation. Fine, yes. But it was said. Look, for me, I am, as I said, people should go back in an enlightened society. That's what people do. You go back, look at the cases is prosecuted, some of them that had all kinds, and then you start asking questions. In certain jurisdictions, I'm sure people have started calling cases back by now. We are still dealing with this. Some are saying, some people are defending. Look, let's stop this gymnastics. It doesn't help us at all. Your Minister of Justice is actually coaching someone to fabricate a story in order to jail somebody else. Why? Why should the Minister of Justice do that?
The retort or response is that the tape specifically did not see, or we didn't hear the AG doing the coaching that say it this way, don't say it that way. It was just a comment from the gentleman.
Salon. I don't think, unless of course you are talking to kindergarten kids, who by the way these days are very smart. Look, even what we've heard so far, it's just enough. You say procure anything, sick leave. Is it sick leave or sick?
Medical excuse.
Medical excuse. That's been damning. These are the people who cheat on their age and then do all kinds of things. They keep receipts in the offices. When you say you should go and buy something, then you go and take that receipt, write another thing and sell. This all that came to my mind. I'm like, but this guy's actually telling someone to procure a fake sick excuse. Really? Then you have to go back to other cases as well and find out whenever he's told the court, I have to go somewhere, find out whether all those excuses he gives us AG were actually true. This is how we unbundle the whole issue. But this Ghana, you're getting this election. People think this is an election matter. It is not. This is a grave matter, a very, very damning matter. And I'm surprised the gentleman is still at post. Seriously, I thought, look, if it were me, honestly, I would have just said, look, guys, let me walk off and then because there's too much heat. And it's making everybody's work difficult. The tier guy, the second guy, nice guy. I see the guy struggling to sort of respond on his behalf. No, we shouldn't do that to ourselves. A minister of justice is look, you are like the chief arbiter when it comes to people fighting, people's rights are being abused. You come in and say, hey, I'm on your side. But no, this man is actually on the side of an oppressive enterprise that is just interested in jailing people for doing no wrong. Why am I surprised? What didn't that happen to Domelevo? What did the Attorney General say? He didn't say a word.
Well, the other response is that the accused person had filed his witness statement, which is evidence in chief. That's what he depends on. And there was nowhere in the evidence in chief that he made allusions to the fact that the AG tried to tamper his evidence or tried to coach him in a way. And so, this may be inconsequential. He had known it all along, but I didn't see it necessary to bring it up.
Salam understood that maybe the case management, he listened to the guy in court. Look, if you dare me, I'm going to say a lot more things. He didn't think he could put all of that in the case, in his pleadings from day one. I think certain things happened that infuriated him, that made him talk. He probably wouldn't have said anything at all. So let's not stop playing this mouse and cat games, really. Nobody is saying that he pleaded these things in the case anyway. The guy got angry at the point and said, look, there are things you've said to me. If you dare me, I'll put it up. So what are we discussing? Nobody is interested in saying that he didn't plead this, so he can't, substantive cases may be affected or not. Look, in any civilized jurisdiction, even this thing that happened would affect the case entirely, immediately. Immediately, the mistrial, everything must just happen. I mean, how? If somebody, AG is caught on tape, telling somebody, procure an excuse duty, you wait for me. Don't say, manage it. You just say this, And then the guy was endlessly having conversations about the propriety of the act that has said to be wrong. And Jakpa is saying, no, it's not done that way. So, okay, this is the way I understand.
Very strong was it?
Carefully choreographed. And I've said that, you see, when people do things to people, you recall this South thing. People think it is just South. Now you see, it's being done to human beings, and that's the way oppressive, how do you call it, oppressors, even in democracies. That's how oppressors actually operate. So I'm surprised that we are even having the conversation as to whether, Dame is right, Dame is wrong, Dame would defend his. What is he defending against this matter? So my brother, I'm sorry, but for me, they've done it to my people. I saw it and I felt it. When I was shouting and fighting, somebody said I'm a talk tank. Now, you see what is happening now? How many more are there? That's the way we should start analyzing these matters. How many cases are there like that? Anyway, good day.
I see. So just I don't know. You are in a car, going somewhere. I don't know, but I just hang in there for me.
I'm here. For
okay, good. All right. So Alex, there were a few things you wanted to say.
A number of things I want to say. This is not about MPP, NDC. It's a criminal trial. You are dealing with the liberties of people. So let's move it away. Yes, there are political sentiments, but let's look at it as individuals whose liberties are at stake because they all carry imprisonment. And in the law that I know, the jurisprudence of the law I know in criminal law, at any point where a court has evidence before it, or that can be brought, that will give somebody his liberty, you can't ignore it. This is not a civil case. Once evidence comes before the court, or they are aware of evidence, it is the duty of the court to obtain it, because you have an innocent person there as you are dealing with a criminal trial, and is innocent until proven guilty. It's not the other way around. We are not French. It's not French law.
Sure.
So it is imperative that when people are saying, oh, the case can just go on, when there's now evidence in the public domain which is going to be put forward, the court has to assess that evidence and the weight it is going to give to it, because it does affect the liberty of one or more of the defendants.
Even if the evidence in question,
yes,
I mean, looking at it purely from a legal perspective,
yes,
does not have any implication on the case in court. When parties have closed their cases, parties have filed their witnesses.
What is your definition of it doesn't have an effect?
Because no, of course, it's for the judge to determine. But
exactly.
looking at it generally,
and I'm saying generally, if somebody is saying, give evidence this way so that I can convict A, B, or C,
and I have not given the evidence that way,
it doesn't matter. It implies that you, because you are the principal prosecutor, don't have evidence to convict somebody.
No, we always want the evidence to be, if you have 100% evidence, the better.
But okay, that is why there's a law or a principle that you don't talk to witnesses. And even my colleagues saying that, oh, they gave this person, look, there are trials where you have multiple defendants or a number of defendants. You don't coerce. You all take your statements, you look at it. If one defendant decides to digress from his statement in the witness box because he has heard other evidence and there's problems, invariably, everybody gets convicted because somebody saw that this person has lied or that person is, because he changes his evidence midstream. So your oral evidence is your evidence more than your written evidence.
Yeah, but the oral in this case, it's just cross-examination. It's not viva voce evidence per se.
When you give evidence in court, your written statement is what they start with. You get into the dock,
and
you are now going to cross-examination, and because of what you have heard in the come out, you start giving different from what you have said.
Yeah, so the cross-examiner will point out the inconsistency.
But I'm saying that your oral evidence is not what was in the tape. It's not ignored. It's looked at as part of the evidence.
It is.
You are sitting in a court and you are now hearing evidence of some, what's it called, conversations that can have a bearing on the type of evidence or the nature of evidence that is going against a defendant or the other. You can't ignore it. You can't say that, wait, let me convict him and then he's going to appeal and now bring that evidence.
But the question is being asked about what the gentleman in question, Jakpa, was doing with this so-called evidence all this while, because these discussions occurred many weeks, months ago.
There are many reasons why people will not bring out evidence. The question is it authentic and the weight you put on it? But the thing is, you now have it. One, you have to look at all these questions you are asking. Why didn't you bring it early? Does that affect its authenticity, etc.? But it is prima facie evidence available at the moment. And you have to get clarity on it. You must, you see, this is not anybody up and down. And our colleague just made, Bob Banson made a very good point. You see, in all this trying to clarify, the position of the Attorney General as the Minister of Justice and the Attorney General for the principal legal advisors to the government means that anybody who has to even investigate this matter, he has a say in the matter when he's sitting in the chair. How do you do any investigation or look at this matter when he's still Attorney General? It is not, look, it's not done anywhere. This is, look, it is wrong. And nobody is saying that he's guilty. Let's make that this thing clear. We are saying that to keep the sanctity of the position of our law and our what's it called, legal system, the allegation is extremely grave. And it is become more poignant because of the denial in the first statement from the Attorney General's office that there had been no meeting. Now you are talking of doctored tape. Doctored in what way? Even in my dear colleague's defense, he's referring to things that were said in the tape. Is it a true tape or is it not? To what extent is it doctored? We don't know. We are taking the tape at face value. And that's why he can take aspects of it and say, well, if he said this, there must have been a question here. Then take all the rest of the things that are going on in the tape. And he has accepted that there was some form of indiscretion in what the Attorney General may have said on that tape. For this matter to step aside. You see, for me, it's not complicated.
But if it steps aside,
yes.
How does it affect the case? The case is conducted by the office, by the Republic. And so
yes,
the case continues.
But I am saying that much as what people are saying, that it doesn't have any effect on how the judge is going to weigh things when she's ready. It is in the interest, I believe, of the court to at least get that issue resolved
first.
And so let me say a point. If it turns out that the tape is authentic, let's say that this tape is authentic, what is the credibility of the prosecutor bringing the case when the guy is saying that you are trying to get me to give evidence? Right now, at the moment, I'm just waiting to see what application Atu Forson's lawyers are going to make, because
they have filed an application.
But theirs is for TV coverage.
That was to that's an application to the the Chief Justice.
Yes. They haven't come to the. You see, because
no, but beyond that, they have also filed
an application to do what?
To do what?
The termination is.
That is Japa.
Yes.
I think there was.
Yes, you see. Look, let's take it step by step, because the lawyers of Atu Forson haven't said anything yet. They said give live telecast. You see, let's be clear. The case can go ahead. The prosecution must. But in my humble opinion, and I may be wrong, let's take it that I'm wrong. But in my humble opinion, the determination of the authenticity of the tape must be made. Because if it demonstrates that the principal prosecutor in the case is tainted, we are not persecutors.
Notwithstanding the documentary evidence and all of that adduced or brought to court by the prosecutor.
He brought it. He's tainted. What is his credibility?
I think there's an application.
The documentary evidence
by the first
accused seeking
person,
to do what?
Seeking for an inquiry into the conduct of the Attorney General, an order of mistrial, injunction, and or stay of proceedings in the instant criminal proceedings.
Okay, I have
that.
Okay. I know
so when
about
was this
the
filed?
Japa. When did this come out?
Anyway,
it's not an issue. So they have also come out.
Yes, they have also
because
come with
I was expecting them to even come before Japa. Because
so
what is said is
there are
actually
3 applications now. 2 in the courts.
Yes.
And 1 to the CJ.
And 1 to the CJ. And the 2 in the court, one is from Jakpa.
Yes.
And the other is
and the other from the from Atu Forson's lawyers. It's for an order of inquiry into the conduct of the Attorney General, an order of mistrial, injunction, and or stay of proceedings. That's from. And then from Jakpa, it is an application for an order striking out the charges and termination of proceedings, and all on the alternative stay. So some way, somehow, there are some.
So it will be brought before the court, and the court will then ask on what basis, and obviously they will tender in.
That's where I was going for the proprietary.
They will tender in the evidence of the tape that we've heard, and if there are others, they can now put it before the court. And that's why I'm saying that before you just saying that the trial will be going on while they are doing an inquiry, for me it doesn't wash. The inquiry the court must be satisfied that look.
Okay, so the stay of proceedings, Laban, may be in respect of because of the new applications brought, so that the two cannot be happening concurrently. So that because you're calling for an inquiry into the conduct of the AG.
Yes.
We don't know how long that process is going to take.
Yes.
So you halt or you pause or stay the proceedings until pending the determination of the inquiry into the conduct of the AG.
You have actually called for the inquiry into the conduct of the
AG. But we don't know how long that's going to take.
No, if I say that has not been granted, and in any case, I don't know if this court even has the jurisdiction to grant that one, because that is not a judicial matter. It is more or less an administrative step. Right.
The conduct of the AG, whether the AG did ABC,
or are they going to do some kind of a mini trial?
Mini trial is possible
to deal with that.
Yeah. So you meet your accuser. You told me this on this day. This is the evidence.
So to be done by the same.
I think the same court could do it.
Very well.
So maybe we don't know how long that process will take. So the stay which we were thinking about earlier could be in respect of this and the substantive matter continuing. Because you may say if you don't ask for the stay, the court will grant the inquiry, but will not grant the stay because there was no stay application before it. I'm sure that's why they put all of them together that way.
Okay, so
let me ask a question.
In effect, it's some kind of mini trial.
Yes, that's what I'm thinking.
For the court to deal specifically with the conduct of the Attorney General.
Yes.
To see whether it warrants a decision for a mistrial. Is that it?
Perhaps decision for mistrial, maybe. But when the inquiry establishes that the conduct was improper, there may be other actions may flow from there. I don't know what actions may flow from there, but that determination they are saying must be made. And while that determination is being made, the substantive matter must be stayed.
So it fits well into the delay.
No, you see, when we talk of delay, I find it very interesting in the way you put it. You see, I have been on a tube, I've been on buses where judges in cases I've dealt with are also on the same version, different jurisdiction. I nod, he nods. At the next stop, I will get down. I'll take the next bus or the next tube. Common sense. You don't put yourself in any position where somebody can say that you had a conversation. So you don't even say hello. Because he was in the court with you when you were doing, and he's going to sit on certain cases you are dealing with. But they take public transport as well. So you're all on the same. So you get off the next bus that comes. Or if it's going to be too long, or the next available, listen, when you get your stop, there's no other further conversation with the judge. Witnesses, defendants, you meet them. No conversation. You have gone to a judge house or not a judge house or somebody. What are you calling the person for? This is a fundamental principle of our practice.
The question I have asked, which is still begging for answers,
so wait,
who made the call?
Yeah, so there were a lot of calls. There were a lot of calls.
Let's assume that I have a problem.
Who
I'm
made the
calling
call
you
to the,
agent
to the
10 times.
To the justice,
10 times.
House.
You should say, we cannot discuss this. Or you report him to the police.
But how about the cultural, the cultural...
No, I'm not saying that...
We are talking about the meeting at the...
so at whose instance? At whose instance?
I'm not going into that.
I think
not going into that because I don't even have the evidence.
The WhatsApp messages we've seen,
yes,
did suggest that Jackpot did or may suggest that
no,
he did.
It was,
and he said he will arrange through his brother.
No, it was the AG who said, I'll arrange
through your brother.
It wasn't Jackpot. Jackpot was rather pushing for when can we meet. I agree on that. But as to where and who, it was the AG who said, I'll arrange through your brother. Namely, we believe.
So your brother even at that point means that there's been earlier conversation.
So it wasn't.
So we knew who the brother was.
But all this is a red herring. You see, you can't say that, because of... Look, do you know, you have been a minister. What kind of pressure don't people put on you? Why haven't you done the wrong thing? Don't people insult you every day because, you were a minister, you were this, you have done this. When the thing is not right, you don't do it. That is how and it's a very difficult scenario. So your family people will be on your case, you don't do it because you are the only one in the dock going to defend it tomorrow. You cannot tell me an AG is having continuous conversations on the face of it with a defendant and there's a situation which I don't even know why anybody is defending this. All we have to do is, step aside. Because even the investigation, how far can the court go without third parties? Is the court going to order, who is she going to order to go and say that, look at the tape and say, is it not CID or NASH or whatever? And all those people haven't got links to the Attorney General. Step aside. Because if they have to make this tape, whether it's doctored, authenticated or whatever, it is our agencies that are going to deal with it. For that to happen, the AG must step aside. Look, people keep talking about, my colleague was talking about ethical. There's unlawful things in this thing, it's not just ethical. I've told you that there's a potential perverting the course of justice or attempting to pervert the course of justice in this matter. So let's be careful.
That is if it can be established.
That's so you are looking, and who investigates crime? Who investigates crime? It's not the court. Investigation of crime is done by CID, Yoko, all those people. So this thing, if with a potential criminality, who is going to investigate it? And the AG is still at post. Please, Let's get real. Look, we are being practical. We are not. This is why I gave the examples of the other two people. And our colleague has made it clear that because of the powers that he holds as Attorney General and Minister of Justice and Chief Advisor to government, it becomes very difficult to carry out any investigation of this sort when he is still at post.
I see.
Even people with less position had to step aside while investigations were carried out. That's all I'm saying. I'm not saying he's guilty.
Yes, nobody has said he's guilty yet. But, best practice. We learn from best practice elsewhere, everything. Even in Ghana, we've given some examples. When such a matter comes up, what was the right thing to do? Do you still stay at post and defend it, given that your continued stay in office may influence the investigation because of the very central role you play, etc.? Will it be the case, or won't it be ideal, or won't it be the proper thing to do that the AG will say, okay, because this matter has come up and I'm innocent, I'll step aside, deal with it, and if the president finds me worthy enough, I will come back again?
So that's a moral question. Okay. Yeah. For now, he has not been proven guilty.
Yes.
It may weigh so much on his own conscience to say that, you know what, I want the truth to be unraveled. Let me step aside. Let that thing.
But what is proper is moral. But what is proper? I mean, so it's a difficult question. What is proper? When you are post, criminal matters, you have to initiate them. You are the one. The investigations, given the central nature of your role, you may be called upon to give advice or do that, and that. You are still at post. You are the person. You are the subject matter of the investigation. Shouldn't you step aside? Wouldn't it be proper to step aside? Wouldn't it be respectful to the public that you serve, and in the interest of justice, that you step aside whilst the processes go on? If you are vindicated, why not? We are all happy. You come back to work if the president wants, or at least your name is cleared.
Yeah, that would be an ideal situation. But we should weigh it against the facts that we have now. I've raised a number of questions which may still be answered without necessarily he being stepping aside. Right? For instance, I first asked, what was the motive for the tape? Okay? Who asked for the meeting? Right? Because initially, I have seen a letter from his lawyer, Mr. Obin, initially, where Big C had made certain proposals for 2 million
which was refused.
Euros. Yeah. AG refuses, right? And in the same breath, we are talking about the same AG who is now asking this man, whose principal, allegedly, made the proposal for 2 million to be used as plea bargaining, right? So you see a lot of contradictions. And I'm saying that there are some answers which could easily be given without compromising the Attorney General's position, even if he's still in office, right? I'm saying that it's an ideal situation where you will say that, no, because even if it is so tenuous against me, let me just step aside. Let the system take its course. And then we can, if the president still finds me worthy, he can still reappoint me, right? But I'm saying that I have given all these questions for us to answer. Should the Attorney General step aside for us to know who initiated the meetings, if there were even more, right? In the bid to have this plea bargaining, was it not reasonable for us to conceive that obviously the accused person and his people would meet with the Attorney General and his people, because plea bargaining cannot be done in isolation. Obviously, it is the two parties. It will still be a discussion somehow of the case. So it is not as though there is everything which points directly to the Attorney General actually influencing. Because I told you that I have listened to the tape. You realize that Jakpa is strenuously making the case, I cannot do it the way you want me to do. I cannot do it the way you want me to do. Yet, whatever the Attorney General is alleged to have said.
We didn't hear that.
We didn't hear that. So sometimes.
And he referenced a meeting in the judge's house. We said that's why when we were always saying this in our meetings, I told you that I'll battle with my conscience if I went ahead to answer the questions your way.
For me.
So let me ask a question of you just before you go.
Okay. For me, the analysis of this tape, it all has to do with the kind of interpretation they would want to put on the LC. You realize that the point of divergence between them, between the Attorney General and Jakpa, was whether it is cash on delivery, actual delivery of the goods, or cash on site of the shipping document. Whilst Jakpa felt that you make payment upon seeing the evidence of shipment, the Attorney General held the position that no, it must be you make payment when the actual shipment or when you delivery of the goods have actually been done. In his case, in that case, he is trying to say that, oh, if that was the case, you would have seen that these ambulances were not ambulances after all. They were not fit for purpose. And so we are not going to pay. The other one, in saying that, oh, you only look at the documentation, it means that when you see the documentation and the documentation says that everything is set, you should assume that everything is set and pay. So it is just about when payment should be done. That was the only point of divergence. How is this going to affect the case itself? And now the case itself is going to be put in abeyance as we deal with the personalities
the
involved.
gentleman is also in his application. He's also alleged that the Attorney General has admitted or confessed to him that he doesn't have enough to convict him, or like he will acquit him in the end. He will get him acquitted in the end. So he wants to more or less use him to implicate or cage Atuforsin. If all those things,
I think that one we should discard it.
Yeah, if all those,
I'm going to explain to you why we should.
We don't know whether we have tapes on those or not.
Okay, if there are tapes, let them bring it. But if the reason why I'm saying that we should discard it is that, in the first place, it is not the Attorney General who will write the judgment. In the second place, the evidence, all the evidence that the Attorney General is going to rely on have already been submitted to the court. And on the basis of that, the court had made a ruling that all the three accused persons had cases to answer. Mind you, the second accused person was discharged on health grounds, not because he had an exculpatory evidence which the court looked at and said that, oh, you are acquitted and discharged. No. All the three of them were held to have cases to answer because prima facie cases had been made against them. The only reason why the Attorney General entered nolle prosequi in the case of the second accused person was that he was terribly ill.
Yeah.
Okay?
All right.
And that's why that came. So if the Attorney General, if you state in your affidavit now, the Attorney General told you that, oh, you have no case to answer, and that we have just added you, but the real target is the first accused. And so tag on and give evidence the way I want it so that we get our main target. I will say that's not true. That is not true in the sense that, one, the Attorney General has no other way of adducing any fresh evidence anyway. He has finished with his case. Two, you that claim that you are being manipulated by the Attorney General have stated it clearly that, look, I'm not going to answer questions the way you want me to, right? So whatever influence there is, zero. Three, at the time of this discussion, the person had already given his witness statement. So nothing more to be added except for cross-examination, right? And cross-examination, if the Attorney General asks you that, I put it to you, this is this, and you say, no, that was not the case, is he going to put something on you to say what he says is the case? No. And that's why I'm saying that that piece of evidence that he has put there, looking at the factual circumstances, is not true.
I see. So
Can I just say
so
this?
in concluding your remarks on this.
One of the questions, or the question I wanted,
You wanted to put to me. I'll answer.
To put to me is or let me put it this way. The evidence that has been brought out by Jakpa, I don't want to talk about things
In respect of the tape or the evidence before the court?
in respect of the tape.
Okay.
In respect of the tape. It is wrong for us to presuppose that, because we all accept that there have been previous conversations on the face of the tape. There appear to have been previous conversations. But the question I wanted to ask was, why would the Attorney General's office indicate that there had been no meetings whatsoever? And then it comes out that there is a tape. Do we understand the strength of the integrity issues in that letter that was sent and the impact on the Attorney General? You see, when I heard Franklin say, I won't believe anything the Attorney General says again, it's because of such things. The Attorney General, if he was going to come out with a statement, should have said, yes, there have been meetings with Jakpa, but I was not in any way doing anything untoward in those meetings. He didn't say that. He said there have been no meetings. Now, you agree there are meetings, but you are saying that the tape was doctored. Where's the credibility of the Attorney General? You see, I'm even saddened. The way my friend has gone, it was the MPP that mentioned the judge in the first place, the organizer. Nobody had mentioned judge. And it was put on the basis that it's the judge who has been part of a setup against the Attorney General. And according to the tape or the texts, it was the Attorney General who said, I'm going to meet the judge. We'll do it at your brother's place. Look, let's leave this matter out. Because people can infer that the relationship between the Attorney General and judges is one of influence. Because he has made the point that it is not the Attorney General who is going to write the judgment. So how are you going to get somebody off? Unless he's going to use his power of an Attorney General to say, after I've heard all this evidence, I'm withdrawing the case at the last moment.
Yeah.
Is the court seized of it at that time and therefore he cannot? Or he as a prosecutor saying that after I've heard the defense, in my humble opinion,
He could withdraw.
that is it.
He did the same for.
No, but that was nolle prosequi.
That's not a prosecutor.
This would be withdrawal.
So I'm saying that is the
Attorney
same
said-
way.
Attorney said
You
he
see,
can
that
enter
is
the
the same way.
Yeah.
When you want to be rigid on evidence in a criminal trial, you have to be careful. And it's happening in some other case. I don't want to go there, where you have evidence that favors a defendant and you don't use it, or you want to exclude it. The jurisprudence of criminal law doesn't allow that.
Very well. Franklin, your final thoughts on this. You have called for the AG to leave. We don't know whether that will happen or not. We don't know whether he will do so on his own or the president will have to make him do so. What do you think the court itself should be doing? Has the court... Okay, I understand Franklin is gone off. We will take a break, but I'm tempted to ask Honorable Aban whether the Supreme Court judge's name, which has come up, has any effect on that judge or the process or anything. What implication does it have for the Supreme Court judge?
These are, in fact, he was in a very difficult position, I must say. Okay, cultural imperatives of trying to assist a brother, and professional calling that, look, because of my position, I stand the prospect of being called to sit on appeal on this matter. So let me stay off. Of course, once there is that kind of filial relationship, he could, if he is empaneled, he could tell the Chief Justice that no, the third accused person
is related to me.
So let me recuse myself. But be that as it may, it will be difficult for him also to say that, oh, I'm a Supreme Court judge, you know, so please, even if this is your case, go and sort it out with the Attorney General. I can't say anything. That's what I'm saying, that it's a cultural imperative as against professional, ethical considerations, right?
Yeah.
And so, if the call by the Supreme Court judge is not to unduly influence and pervert the course of justice, but for instance, to see the possibility of getting his cousin to engage in some kind of plea bargaining discussions, why not?
Okay.
You understand? Yes.
All right. Okay, good. So we are moving on to the next matter. I take a few messages that have come through. This one, from Okroku Asante Sechi says, how long do you think it will take a court to try me if I borrow someone's goat or yam? Why is this case taking so long?
It's not about goat or yam.
Tete Moses says, please know that Mr. Japa is an accused person. The third accused in this case is not a star witness. Donis Kweku says, as a country, we have a constitution that we use to govern our nation. What does the code of conduct talk about? The actions of the Attorney General concerning him talking behind the scenes about the trial. To take the constitution, if he has committed an offense, the law must deal with him. This one from Musa Batwa says, I totally agree with Bobby Bansin. The matter is a very serious one. The recent developments in the ambulance case, where the Attorney General Godfrey Dam is allegedly caught on tape trying to influence a witness, you said is to implicate out to force, and you said is not good. This one from Chris says, Salam, the MPP is just dishonest. They have never taken responsibility for their wrongs, and every tape that emanated from their camp is doctored. We are living on an animal farm? They are the only righteous folks and first-class citizens in Ghana. You see, they have turned the Attorney General into a vicious prosecutor, or is a persecutor, to eliminate their political opponents by hook or crook. This Chris from Ashalebutri. We'll take a short break. When we return, we will look at the matter of the Pwalugu Dam. But of course, there's this LI 2423 that has been cited many times by people. I just bring it to you. The duty to assist the court, that's the duties of a prosecutor. 56 2D says a prosecutor shall not confer with or interview an accused person. So this has been thrown out in the mix. People think that what the AG did amounted to conferring or interviewing the witness or the accused person, and that is not right. Of course, all these things will feature in what the accused people are seeking to do in the inquiry, and we'll see what the court or whatever body will be set up to do it will do. This is the big issue. We will come back and discuss the Palugu Dam matters. Don't go away. All right, welcome back. This is the big issue. We are happy to have you join us. We just discussed the matter of the ambulance procurement trial. We tried to analyze the implications of the leak tape that the NDC put out this week, that purported conversation between Richard Jakpa and the Attorney General. The MPP has said that tape is doctored. We don't know if they have another one to show the level of editing or doctoring, if you like. So as we have it, that's what we have. Calls have been made for the AG to step down. Others say no, he won't step down. The NPP says he will not step down. Franklin Kuju of Imani says the AG should step down. The NDC, represented here by Alex Segrifa, thinks that he should step down. Bobby Bansin, a private legal practitioner I spoke to earlier, also thinks that given the role of the Attorney General in all the matters, he must step down. So we have a fair system or a fair hearing on the matter. Now we switch issues or topics or gear and speak about another matter that has come up in the week, the payment of some almost $12 million to contractors of the Palugu multipurpose dam and irrigation project. The NDC minority visited the site and they say that no work is there, it's been done, there's nothing to account for in terms of the $12 million paid. And so it does appear that the contractor just took the money and left, and nobody is saying anything. They think that some misappropriation has happened. I think I'll start with the Honorable Alessegbefi again. His side visited the place. In fact, there was some visit there in 2021, and the minority group were happy, or the committee was happy that some work was happening. But it does appear that since then, nothing much has happened. They say the contractors have moved their things away. We also visited the place as a station, and of course, we did see that some containers were there, but the site has been deserted or abandoned, which means that no work really is going on. We'll show you videos of what we went to see when as the show goes. So, Alessegbefi, tell us what your people went there for and what their concerns have been.
Okay. Let us be clear that the Pwalugu Dam project was initiated in 2013 under the NDC government. In fact, we commissioned and paid for a feasibility in 2013 by a company called Tracabel. And we had FDA, the French, they are called FF or AFF, Agents for Technical Advisors for, were the ones who gave security for that feasibility to be done. The president of Ghana, Nana Addo, cut sword on this project in November 2019. At the time he cut the sword, there was no financial arrangement in place for the dam.
November 2019.
Yes. In February 2020, the agreement to have the dam made was brought to Parliament. The total sum was 993 million for it to be done, of which Ghana government was responsible for 12%, and the other was being obtained from the Chinese. China was going to help us to do it. Because China had the biggest stakeholding, they decided that they would use one of their major companies, I think it's called Power China International. I stand to be corrected, to be their representative, to be the contractor. So the way it's supposed to work is that, and I stand to be corrected, as the project continues, at any point, Ghana government pays 12% of any certificate that is tendered. Now, in the people are, it's Power China.
Yes, Power China, yes. The Power China are the contractors.
Yeah. In 2021, it became clear that China was not interested, or in 2020, thereabouts, were not interested, or were no longer going to go ahead with this particular arrangement. The minority had raised concerns about the nature of the contract at the time, but based on the fact that it was deemed going to be in the interest of Ghana for the dam to take place, notwithstanding the concerns we had, it was passed in Parliament. But now the Chinese, looking at our position, we believe.
So before that, so this is a site we visited, and this is what our cameras captured. There's a bare land, some trace of sand and stone, and a few blocks here and there. This is what we saw when we visited the place.
This was when?
This is just a couple of days ago. I mean, after the matter broke. So this is the place.
This is the area view.
This is the aerial view. So some, small camps here and there. But what was clear was that the site was deserted. So that's what we see there. But the site, nothing is happening. The site has been deserted. Yes. So this is it.
Now, all this construction, if you can call it that, has nothing to do with any Chinese money. That's the first part. So, Ghana government paid 11.94, close to 12 million, to the contractor, Power China. And we are being given some explanation for what we don't know. Because the whole idea is that we were going to pay counterpart funding. So whatever we put in, by now, there should have been some Chinese money to match our 12 million. We haven't had a dime from the Chinese company in question. We haven't had a dime from the Chinese government. And at the time when we paid the 12 million, we were aware, I am informed, that the Chinese, for want of a better phrase, had taken cold feet because of believed our financial position at the time as to whether we were going to be in a position to deal with this extensive amount, close to $1 billion project. So it was like a wait and see situation. So we should not have paid the 12 million.
We shouldn't have paid the 12 million.
Because to such time that we had full assurances and guarantees that they were really had the money and they were going to get on board, you shouldn't have paid it. Because once you knew they were not going to go on board, you should have then looked for an alternative. You can say, okay, look, the Chinese are dragging their feet, they are not interested. Let's go and see whether we can renegotiate. Because the feasibility had already been done and paid for. Let's go and look for some other. As it stands, subject to what others will say, the project is not going ahead. We have paid 12 million to who and for what? Because what we see is not 12 million. The feasibility had been dealt and sorted out in 2013. So what again are we paying for in terms of administration and whatnot? That it's not adding up. Then for me, it came that in the document that came that they said final payment. That's what brought the whole issue. The document had said final payment for this. And the question then was asked, a final payment for what? Because there's nothing happening there. We come, the MPs, we come from there, there's nothing happening. So what is the final payment for? And we were being told it's mobilization. But what is the amount of mobilization? And if mobilization is part of the certificate of sorts, and you are bringing in Chinese contractors who are supposed to bring 88% of the money, why did you pay 12 million and get them to then pay the equivalent for the mobilization? Because depending on which document you look at, the mobilization is supposed to be in the region of 40 or 60 million.
48.
48.
40. The 12% was supposed to be $48.7 million.
So we are supposed to pay, I don't know whether 12% of that is the 12 million or whatever.
So 12% of the total contract sum,
but
400 million.
We must have been able to see some money from the Chinese. But the problem for me is that they knew that the Chinese had cold feet. So we had no business releasing that 12 million to the company. And is it a position, are we in a position to go back and say, please, can I have my 12 million or not? If not, problems are going to arise tomorrow. So I know that one government institution has come out with an explanation as to what was paid for and the same mobilization. It's not adding up. Because what we have on the ground, mobilization means you have started the project. You are going to start. What we have on the ground does not match 12 million. And in any event, where's the other part of the funding? Because ours is counterpart. And what is happening to the contract? That is why they say it smells. And it was this, what do they mean by final? Is it final payment of the mobilization on our part? Or is it, and it wasn't clear. And so those who have written the report should also come out and explain. Those are the questions the NDC in the minority in Parliament are asking.
Okay, let me speak to Professor David Miller, who is the Vice Chancellor for the Miller Institute for Development Studies, and also the Pro VC for the university.
While you are speaking to him, he also made a statement that there were some other payments which are not part of this 12 million that have been made. So maybe he would like to clarify on that as well. That's what we are told.
Okay, all right. So, Prof, welcome to the program. I hope you are well. Tell us what your understanding of this project really is, and if you have any idea at all of the feasibility study that went into the project, we'll be happy to know. Hello, Prof.
Maybe he has to unmute.
Prof, I understand you may have to unmute. Kindly unmute so we can hear you. Okay, so I'm sure he's getting help with his gadget or Zoom. Alexander, let me come to you. So yes, well-intentioned project, Palugu Dam. You know, for many people, had it not been events of this week and last week, people would have thought that the dam was almost nearing completion. Here we are, nothing really has started on the ground.
The date for completion, it was a 48-month project. Date of completion is November 2023.
I see. So the thinking is to have been done, but here we are, we've not really started. I don't know how you see all of this, the fact that some money has been paid, not so much to show for it, and there have been allegations of misappropriation, etc. What do you think, Mr. Aban?
Thank you very much. I don't have so much information about this. So I was listening with rapt attention as you went through the history of this. One thing, one confidence it gives me is that by and by we would agree that when one government starts something, another will have to continue, because he said it was started in 2013. It's something I have no idea about. Thankfully, they felt, or the NPP government also felt, that it's a good project to proceed. For me, so long as we have seen that it's a good project and that it should be done, we must do it and do it well. And it should not be an avenue for anybody whatsoever to just take our money and go scot-free without accounting for it. And so I wouldn't say much if indeed, as he said, at the time we were going to make the payment, there were clear signs, palpable evidence that the Chinese who were supposed to give the counter funding, which is even more, that's the 88%.
88%.
We're no longer going to do it. It means that from get-go, we will not be able to succeed. So it will be an exercise in futility to go and get somebody to mobilize. Because when you give the person mobilization, what it means then is that the person is trying to gather all his equipment and personnel and all that to go to site and start a project. But a project where the funding itself seems to have some heavy cloud around it, and it doesn't give any clear signs that it will come, why should it start in the first place? Right? And so, for me, thinking Ghanaian as I always do, let us delve into it. If indeed what the minority is saying is true, let's get those who are who are involved and ask them the relevant questions. Okay? Because if there's a 48-month project, by the calculations or reckoning of time, at this time we should have been ready, right? Now, what he said was that the Chinese developed cold feet. What led to that, we don't know. That's point number one, which we must think about. Two, at the time that they developed the cold feet, had the government committed itself in terms of some kind of contract with the implementing or the construction company, such that if we did not pay that, we're going to actually be in breach of that agreement? Thirdly, was the Ghanaian government required solely to secure funding for the mobilization without necessarily affecting the contract works itself, or the Chinese government or the Chinese counterpart funding was also going to pay the 88% of the mobilization? Because if the Chinese counterparts was going to pay the 88% of the mobilization, the question we should ask is the nearly 12 million which was paid, if you quantify it, is it
up to the job done
12%
so far?
of
the job,
what it was supposed to be done, and what has been done on the ground, and of course mobilizing everything to site? Does it amount to that? What about the demobilization that they have now done? Because according to your own reporters, nothing in terms of machinery is there. Meaning that even if they carried their machinery there for the start of the work, now those machineries have been demobilized. So these are relevant questions, and as thinking not politically, I don't like that. Thinking as a Ghanaian, let's get into it. If we get into it and there are questions to be answered, let's get the people who have the answers to provide it.
Very well. Let's speak to Professor David Miller. We tried earlier on Zoom, but it appeared we are having difficulty. We've reached him on phone now. It does appear he has some information or some understanding of the project. So let him help us now. Hello, Prof. Good morning and welcome to the big issue. Hello, good morning, Prof. Professor David Miller, good morning. Oh, we are having difficulty with Prof. But just to provide some information from the press statement that the Ghana Irrigation Development Authority put out after the matter broke, we see that, I mean, in terms of the current status of the project, we hear or we read that the projects were originally scheduled to be financed under the 2 billion Master Project Support Agreement with the Chinese state-run Sino Hydro Corporation Limited in September 2018.
Yeah.
All right, so Prof is back. Hello, Prof. Good morning. Hello, Prof. Good morning.
Okay. But I can hear you now.
Yes. Thank you so much for your time this morning.
Oh. Uh-oh.
We're having difficulties with Prof's line. The producers will work on that a bit, and then we will see. So, as I was saying, so unfortunately, this arrangement stalled, and government had to fall on its regular budget to finance it. Given the constraints with the national budget, the government is working on an alternative dedicated funding source to ensure all components of the project can be executed without any hiccups. The contractor has raised IPCs awaiting payment, pending the arrangement of the alternative sources of funding outside Ministry of Food and Agriculture's budgetary provisions. The APC contractor has agreed to temporarily halt works on the project. This is to forestall some potential risks to the project. That the well for the irrigation and the hydropower dam must be constructed either in consonance, or the hydropower dam must lead the well construction to prevent the irrigation infrastructure from being affected or destroyed by the floods. If not done concurrently, the irrigation infrastructure will be washed away from huge inflows often experienced during the Palugu Dam spillage. I wanted to quickly account for some of the money. So the contractual arrangements and activities undertaken so far. So there's been detailed. So Power China commenced mobilization to the site in April 2021. The following are brief descriptions of all the activities executed by the EPC. So there's detailed engineering designs, construction works, contractors, campsites, and all of that. I have Prof on the line. Let me try for the last time. Hello, Prof. Good morning. Welcome to the program.
Good morning and good morning to your cherished listeners and viewers.
Great. Yes, we've been following this matter in the past week, and you appear to be one of the names that kept coming up. What do you know about this project? We understand feasibility was done some 10 years or so ago, but the project really hasn't taken off the ground. What do you know about this project, and what is accounting for its current status?
Well, thank you. I offered a consultancy service to the project in 2021. And basically, it was an environmental impact assessment report that I had to do stakeholder consultations on. In fact, it's EPA that contracted me to do the service, not the project.
Okay.
And at that time, there was no development on the dam side. If there was development elsewhere, I wouldn't know. But for the dam side, there was nothing there. I had to go there twice, and I've visited all the stakeholders that are linked to the project and had their inputs and so on and so forth. So basically, I had to write a report. Now, in the process of doing my work, I also had to review the IAA document of the project, written by the project itself. So that is how far my knowledge and input had been. But I've since been doing a bit of local advocacy, first informing the stakeholders about the real implications of the project and the impact in terms of the negative impact and some challenges. So this I've been doing since 2021. Anytime I have the opportunity, I share my experience and the knowledge that I have with them. So this is what I can say for now.
I see. So what do you know about the fact that the project has stalled? I mean, as a consultant who began with the project before it stalled, what is your understanding of what led to the project stalling?
Yeah, the project has gone through a couple of phases. But let me pick the last two phases. One phase was during the time of NDC. And the design is basically the same design, but the funding was a problem. The position that I read from the NDC engagement was to look for a dedicated funding institution outside. That is dedicated funding. Now, that took them quite a while. And I don't think they succeeded in getting that dedicated funder. Because for me, my argument is that it's because of how complex the project is. Because it deals with hydropower, solar power, agriculture, flood management, domestic water provision, and development of a township. It's really a very multi-purpose, complex project. So NDC couldn't succeed in getting this dedicated funding. Now, when MPP came into office, their position was to commit GOG to the project. And that enabled the project to take off, and for some of us to do the things that we did for the project. But it looks like the GOG funding also wasn't regular. We know the antecedents to that. And apparently they had other sources of funding. I don't know from where, because the documents don't show. So I think that is how it came that MPP could start the actual implementation. However, that implementation also suffered some hiccups. And that is why it has been stagnant till now. It's basically not the design. It's not a design program. It is basically a funding and an implementation program. That is what I see, I read from the document.
I see. There are some who have questioned why government will go ahead and pay mobilization when we're not very sure that the counterpart funding was going to come. And so that money paid appears to have amounted to nothing now. What do you think about that?
Yeah, that should be true. Because their position, NPP's position, was to start with internally generated funds, GOG funding. So I'm sure they had a pot of money to start. I can't say for sure, but I think that enabled them to do the mobilization. Once it was GOG funding and it was passed by Parliament, maybe they had a sort of green slate to start funding. And they said, well, maybe we'll start with mobilization, which is the right thing to do. That would be my thinking, and I think that should be the logic. But maybe after they did the initial GOG funding, they ran into the same problems that maybe NDC anticipated, that they will need some huge external funding to be able to execute the project. So
I see.
It sounds quite plausible that because of the GOG component, maybe they are GOG funding to do the mobilization. But when they turn the mobilization to read like the project complete report, then it's quite worrying.
I see.
Yeah.
The other question that has come up is whether what has been expended or the work on the ground, the so-called mobilization done on the ground, vis-a-vis the $12 million can be justified. Does the work on the ground reflect $12 million? People have questioned it and have even suggested some misappropriation. You know the project very well. Not to say that it doesn't amount to 12 million, but what do you think generally? Work on the ground vis-a-vis the 12 million, justification, what do you say?
What I can say is that the project had sub-components. Like I mentioned, one was the hydro, the other was the irrigation, the third was a 30,000 population water supply to Wale Wale. Then there was a township to settle workers. Then there's a road component. So there are all these activities that constitute the complexity of the program. But they are not prioritized. It's not clear in the document which should be done first. That must be verified. It doesn't say which one should be done first. So I think in a certain wisdom, using some logic, they might have rearranged such that the mobilization, the settlement became first, and therefore spend that type of money on the settlement. Because the roads are not done by the description of the project document. The dam water itself is not there. There's no sign of anything happening. The flood control is not there. The irrigation is not there. So all those things are question marks. But the settlement is part of that component. And in fact, the dam wall is of two types. There is the main dam and there's a rear. A rear is a smaller dam that would boost the main dam so that the water can go far. So those are the sub-components. But all the other components, my visit has shown that nothing has happened there so far. But I think it's the settlement part that they think $12 million was spent on. I have my doubts, but I'm not a financial person. I can't ascertain whether it's worth 12 million or not.
I see.
That is the only thing that can be physically pointed at as a project component investment. All the others, I visited them all, they are not there.
I see. So you are telling us that the, what do we call it? The relocation. I mean, the resettlement part, is being sorted. Is that what we are understanding from you? That is it relocation or resettlement is being paid the people?
No, there are two types of settlement. One is settlement of communities that might be displaced
Yes.
by the dam water.
Yes. Have those been compensated?
Yes, and there's also a settlement for staff.
Okay.
Aha.
So which one has been done? Settlement for staff. Is that what we see in the pictures and the videos?
That was what I saw.
Okay.
I haven't I haven't been to a resettled community.
Okay.
But when I visited the site, I saw the workers attempt to resettle workers.
In the camp? In the camp that was...
It's far away from the dam side. It's not at the same place. Yeah, it's another community adjacent to the dam side, but it's a bit of a distance. But having made those arguments, by and large, the purpose of the project first was to manage the flood. And I didn't see any sign of flood management. And then to produce some hydropower combined with solar, and also to do irrigation. For me, all the others are ancillary. The road development, the settlement of staff, even the communities to be settled. It's not sure. It's only by design that they are guessing if communities will be settled. But from my technical experience and professional expertise, many more communities will need settling than captured in the book.
I see.
Many more. Yes.
Many more, which means that the budget could even go up.
Yes. Even without a dam, for flood control, you don't erect dams to control floods. I've said it over and over again. When you erect a dam wall, it is to block the flow of water. Now, what you do is that downstream flood management, you can be sure that the wall will manage it. But upstream flood management, that cause concern for the development of the project will not be managed by a dam. You are literally now blocking the flow of the water upstream. That's the back of the wall. And this water will spread and displace many more farmland. In fact, the project design is a very honest one. If you see it, they anticipate displacement, they anticipate the destruction of biodiversity, they anticipate the destruction of facilities like schools and clinics and so on, by just blocking the water. But they fall short of saying that even the Palugu border highway would also be flooded. So that's why I'm saying that in terms of the disaster that we should anticipate, it will be more than what was even captured in the project design. And the worrying part is that this will be in Upper East. Meanwhile, the rewards or the benefits of the project are largely in the Northeast region. So the Upper East people will bear the brunt of all the displacements of land, of farm activities, of schools and roads, and even their farmlands and homes. Then the irrigation area and all other things are in Northeast. So that's how it is.
I see.
So I anticipate that there will be a need for a lot of compensation, a lot of corporate social responsibility actions to contain the negative or the challenges that would appear in Upper East.
I see.
As a result of the war.
And all those challenges have not been adequately captured in the project document, you say?
Yes. Yes. And for me, it was a very rich document for a project to accept that this amount of such happened. Only that it has been on the conservative side. Well, I live in the area for many years, and I know what will happen.
I see.
The other part of the project that is not mentioned is that this dam, if built, would inure to the benefit of 7 regions, not 2 and not 1.
I see.
The water after irrigation would benefit Savannah, Upper West, the northern part of Oti, and the northern part of Brona Hafo. So you have 7 regions that will benefit.
I see.
And yes, and also for me, as a professional, there are more things after the irrigation area than in the irrigation area. Because what I mean by after is that the so-called wastewater, which has been used by the irrigated land, when they flow, because they have to flow away, those can be used for developing a lot of enterprises, including water transport and fish farming.
Very well.
Yes.
Very well. Thanks so much, Prof. We appreciate your time and sharing your in-depth knowledge on the project with us. We are grateful.
Yes, but I'll conclude by saying that let's see it as a national project rather than a project that will turn the north around or a northern project. That is my plea.
Very well.
Let's see it as a national project, and I can give you the possible figures that will come out from production in the project. That will benefit the country.
Great.
117 tons of rice, 49 tons of maize, then 3,600 tons of fish. Honestly, it will benefit the nation rather than to say it's only to turn the north around. Thank you.
Thank you so much, Prof. Prof. David Miller is a former Pro-VC of the UDS and VC for the Miller Institute for Development Studies. Said he was a consultant. He was actually a consultant on the project when he started. Well, he is giving some information on the project and all of that. From what he says, it does appear many other things were not captured. And so it also looks like we may have to cough out some more money. I mean, many years ago, it was 993 million. Given things, the fact that things have changed now, I'm sure it will balloon a bit. In concluding, how do we proceed with this? We said we should look at it as a national project, which is the case.
A feasibility study is done in 2013. We spent money. We now know that this is what everybody agrees it has to be done. It's costed, and we are at 993 million. That's close to $1 billion.
Yeah.
Now, the Vice President has made comments regarding how this is one of the projects that his government is doing. And unfortunately for me, once again, I find the MPP in a position where they talk about things without telling us where the money is coming from. The 993, we thought we had funded. We don't. And I suspect, and I may be wrong, that when you look at the fact that it was in 2019 into 2020, this thing, the Chinese themselves looked at our books and felt to release $1 billion at this time may not be the best for them to do. We decide that we need to make some political mileage from it, so we start sinking money into it, knowing full well we haven't yet secured the money for it. Too many times. We asked 111 hospitals, where's the money for it? We were told the money will come when it's ready. We are still struggling to finish. So this idea of not securing funding for projects, and we know how GOG works. So when you take huge projects and put it on that GOG, it creates a problem. And the moment you've done it for one, don't think of doing it for another. So this 12 million should never have been paid. Go and do the necessary that you need to do, get the homework, sell it on the basis that, as he has said, it's going to generate power, so we'll make some money. There's an irrigation aspect for it. It's going to bring crop. We are going to get food. We are going to make money. There is also extra energy going to be created because there's a solar, I think, aspect to it. Yeah. So it is, on paper, a self-sustaining project. That's why everybody's interested in it. So how you sell it is important. But if you don't have the money, don't start. Because now it has become a political issue, which my brother is always unhappy about, and quite rightly. But if you spend 12 million, and we don't know what the 12 million is for, where has it gone? And to who? And for what?
I see.
And even if you have paid 12 million to even Chinese contractors, who you knew were never going to be able to do the project, are you going to retrieve it or what? So, I mean, there are legitimate questions that have been raised.
And answers must be provided for those.
And answers must be provided
very well.
for these issues.
You are speaking my language.
Right. Good. So
my
to
question
conclude,
yes.
yes.
Doesn't mean the project will not come off.
Because now we don't have the money.
Because we don't have the money. But you look at it, you listen to everybody on either side of the political divide, and you realize that it's a good project. So why don't we redouble our efforts, make sure that we are able to repackage it and sell it well, because after all, the person who is going to invest in it also expects to have some kind of return on that investment. So what are we doing? Let, I think, proceed devoid of partisanship and look at the project for what it is worth, and then move towards it with a concerted effort without all the bickerings, because it is these political bickerings that make the outsiders think that, hey, look, this is going to create some political tensions between the political parties, so let us stay away. But if we can all think right and move towards its achievement, I think Ghana will be the better for it.
Great, thanks so much. That's the Honorable Alexander Aban concluding the discussion for us today. So we've heard on this matter from Professor David Miller, who is a former VC for UDS. He said he was a consultant on the project. And also we've heard from the Honorable Alex Segbefia, former health minister and the Director of International Affairs of the National Democratic Congress. My name is Selom Adunu. Thank you so much for doing the listening and the viewing. Catch you same time next week for another exciting edition of The Big Issue. Have a good afternoon.